So the other thing I want to say is about thinking of something as a legal regime, as a, let's say, cyber regime. I come to this question because now, having become a great expert in cyber in the past week, I've read that there is a disagreement between the West and then China and Russia that has to do with this question. It has to do with whether there is a vacuum in the international legal order, and we need a regime, a new regime. Or whether, public international law as it is can do the thing. Now, in the past 30 years, that question has very often arisen, and it has been dealt always in a very, always in a manner that resembles, or in a similar way. So, when human rights emerged to the international scene, human rights lawyers said, well, public international is just too state-centered, and we have different values, different concerns. Human rights law and public international law have nothing to do with each other. Human rights is a regime, so they set up special bodies such as the European Court of Human Rights, and here is a famous quote from the Loizidu case against Turkey. This has to do with northern Turkish situation, a Greek who had lost her property there. Turkey had made a declaration saying that the European Convention on Human Rights should not be applied with respect to Northern Cyprus. And this woman from Northern Cyprus comes then to the European Court of Human Rights and says, and files a case against Turkey. The court is now confronted with how to understand the Turkish denial of jurisdiction from the European Court. In public international law, there are standard ways of understanding reservations of this type. For example, in public international law, under general law of treaties, you either accept the reservation and the state is a member of the treaty with the reservation, or you don't accept the treaty, in which case the state doesn't become a member at all. Now here, the European Court wanted to avoid both of these things. It wanted to give justice to the Greek complainant. But that was possible only if it accepted that Turkey had become a party to the convention and erased the Turkish reservation. And that's what it did. But in order to do that, it had to say, well, human rights is just wholly different from public international. We haven't heard about that. So treaty interpretation, no. You have to understand that we are a special regime. We are human rights, not public international law, and therefore we act differently. When the WTO was created in 1994, the drafters of the WTO treaties were very keen that in the WTO organs, they would only apply WTO treaties, and not like environmental treaties or other international law treaties. No. It's just, this is a trade operation. And we are trade experts. We don't want those extraneous arguments about environmental things or human rights things to intervene. And that's why they wrote in the Dispute Settlement Understanding, this article, recommendations and rulings of the dispute settlement body cannot add to or diminish the rights and obligations provided in the covered agreements. So that's technical wordings for saying we are a special regime, we are a cyber regime, and cyber principles apply. We are a trade regime, so trade things apply. So what happens? Well, of course, these bodies have people who have varied experience. And in the European Court of Human Rights, in another case where it seemed to be useful because of the political leanings of the court or its human rights leanings, it insisted that, well, you know, somebody had made an argument that human rights is different from international law. But the court here says, no, well, no, the convention cannot be interpreted in a vacuum. It should, so far as possible, be interpreted in harmony with other rules of international law, of which it forms a part. So which way do you go? Is human rights different or isn't it different? Here is one of the first decisions of the appellate body of the WTO, in which it started to interpret WTO agreements. And so it said, WTO agreements should not be read in clinical isolation from public international law. Now so ethnographically and politically, it's really interesting. See, so who gets into these bodies? What are their priorities? What's their training from background? How do they see things? There isn't a way to say the one is right or the other one is wrong. These are strategic choices that institutions make. They sometimes want to withdraw, and, oh no, I have nothing to do because I'm special. And at other times to say, of course I have jurisdiction because I'm just part of the general. So there are strategic choices. You act under existing law. This is the American, the UK, the Western. So, cyber law, there's no need for a cyber law because the international law already covers. And that's a position that is strategically useful because there's already much experience. I am producing some of that experience in front of you in public international law, which clearly is applicable to cyber activities. Coherence with the rest of the law so that human rights, trade, environment, cyber, that they come together in a coherent way is valuable to some extent. The problem there is that if you accept it, then you're bound by earlier actors and the way the system has developed in the past. Now that's, of course, the West has an interest because the West has developed international law. International law is a European concoction with some American details being put in. And of course, if you are a Chinese or a Russian person, you would not want to sell your soul to that set of institutions. Instead, you say, no, we set up a cyber regime. Because in that new cyber regime, with these new, technically complicated, well-polished rules, I am now the master. And those people who created that old law, they must shut up. We can now do this all from scratch together. Now, we have been in exactly that situation in the 1960s, when after decolonization, new states were saying, we are not bound by the old law. It's tabula rasa, they said, in the UN General Assembly, in a huge number of articles, essays, books that came out in the context of the international legal debates on decolonization. Are new states bound? Aren't they bound? Now we have some experience. To some extent they were bound and had to accept it. There were some exceptions to that. Because they were weaker than the West, the exceptions were really small. And by and large, they had to take the international legal and diplomatic system as they found it. It was changed only in the margins. So, to create a new regime, to imagine that cyber is a regime of its own, gives freedom to the cyber people. No automatic application of anything old. Most things are still unregulated. We can fight it out. It's not that we have to accept some war that's been waged before we were born. We can now fight it out. The thing is, it just may not succeed. Because, as we saw, both in the European Court of Human Rights, in the WTO, and in any other circumstance I can think of, usually the old tends to prevail. The world is made in that way. This is a couple of paragraphs from the International Code of Conduct for Information Security that the Russians and the Chinese and Kazakhs and some others presented to the UN General Assembly. And you can so clearly see here the effort to create a special regime in which new values, new objectives, could be consecrated as the official values and objectives of this new system. So, for instance, the operations should comply with the Charter and is in regard to every country respect the diversity, history, culture, and social system of it. And the idea is to curb dissemination of information that incites terrorism, and those two words, separatism, so China, extremism, so Russia. And none of this is, of course, in the UN Charter or in any other Western accepted traditional law. Then there are these couple of other provisions there to respect the rights and reputations of others. I'm doing a little bit of historical work on the history of diplomacy, and in the 18th century already they thought to refer to reputation is really problematic, and we need to get rid of that. National security, public order, public health, or morals. Well, you understand, so these are strategic choices. So if I'm able to create a cyber regime, then I am the master of that regime, and I can ignore what the general law says. My third point is just a few.